So on February 10th, 2020, the Supreme Court had passed a judgment essentially upholding the center's amendments to the Scheduled Caste Scheduled Tribe Atrocities Act. So the central government passed an amendment on the SC/ST Atrocities Act, also known as the Prevention of Atrocities (POA) Act, on August 2018, and the February 10th, 2020 Supreme Court judgment has essentially upheld the central government's amendments to the Act. So this has in effect revoked the Supreme Court's previous judgment, which was given on March 20th, 2018. In practical terms, this judgment has said to restore the original intention of the Prevention of Atrocities Act, which was passed in 1989. So, what is the previous Supreme Court judgment? What is the original intention of the POA Act? What was the verdict given on February 10, 2020, and what was the amendment passed on August 2018? All of this will be looked into detail. So let's move on. First, let's look at the Prevention of Atrocities Act in detail. So starting with the historical origin of the Act, in accordance with Article 17 of the Indian Constitution. So the Article 17 of Indian Constitution criminalizes and penalizes the act of untouchability. So in accordance with that, in 1955, the Untouchability Offences Act, UOA, later renamed to Protection of Civil Rights, PCR Act, was passed, which prescribed punishment for any disability arising from the practice of untouchability. So the PCR, Protection of Civil Rights Act, regarded untouchability as a crime and prescribed punishment for such acts. But as the PCR Act covered offences of untouchability but not of atrocities, the Prevention of Atrocities Act of 1989 was enacted and enforced on 31st January 1990, and the intention of the Act was to prevent atrocities against members of scheduled castes and scheduled tribes. So in essence, the Protection of Civil Rights Act only considered the crime of untouchability but neglected the atrocities committed against the members of untouchable communities. So to rectify this, the Prevention of Atrocities Act of 1989 was enforced. So let's look into the intention of the Act. So the Prevention of Atrocities Act, originally passed in 1989, is an act to prevent the commission of offences of atrocities against members of scheduled castes, SCs, and scheduled tribes, STs. The Act also has multiple provisions for the relief and rehabilitation of the victims of such offences. So, the Prevention of Atrocities Act not only aims to prevent the commission of offences against members of the marginalized groups, namely scheduled castes and scheduled tribes, but also has provisions for the relief and rehabilitation of the victims. The Act covers multiple cognizable offences. So what is a cognizable offence? So any offence for which an FIR has to be filed in the police station is considered a cognizable offence, and a case will be undertaken under the Prevention of Atrocities Act when the victim is from the scheduled caste or scheduled tribe community and the accused or the perpetrator is not from the scheduled caste scheduled tribe community. Hence, an offence committed by a scheduled caste scheduled tribe or another scheduled caste scheduled tribe person will not come under the Act. So what this means is that a case will be filed under Prevention of Atrocities only when the accused is not scheduled caste scheduled tribe and the victim is scheduled caste scheduled tribe. So this is the criteria for applicability of the Prevention of Atrocities Act. So moving on, let's look at some of the salient features of the Act. So here are a few directions given by the Act. For speedy trial, the state government is directed to establish an exclusive special court for one or more districts. Another direction is that the concerned station house officer, SHO, investigating officer, IO, that is, the concerned police officer who is in charge of the case is directed to conduct the investigation and file charge sheet in the special court within a period of 60 days and to explain the delay, if any, in writing. So, similarly, the courts are also directed to ensure that cases under the Prevention of Atrocities Act have a trial period of less than 2 months. So, the courts are directed to complete the trial within a period of 2 months. Moving on to other important features of the Prevention of Atrocities Act. One of the more noticeable features of the Act is that Section 438 of the Code of Criminal Procedure, CRPC, is to not apply to persons committing an offence under the Act. So, Section 438 of the CRPC is not to apply for offenders under the Prevention of Atrocities Act. So, what is Section 438 of the CRPC? So, Section 438 deals with the granting of anticipatory bail for offences. So, what this means is that an offence committed under the Prevention of Atrocities Act does not have the provision for anticipatory bail. Similarly, Section 360 of the CRPC or provisions of the Probation of Offenders Act is also not applicable to persons guilty of an offence under the Prevention of Atrocities Act. So, Section 360 of the CRPC deals with the granting of probation to convicts on the grounds of good conduct. So, in essence, offenders under the Prevention of Atrocities Act do not have this privilege of probation. So, the most important point is that the Prevention of Atrocities Act is to override other laws save as otherwise. So, what this means is that if there is a contradiction between a direction given by the Prevention of Atrocities Act and some other legal document, then what is directed by the Prevention of Atrocities Act shall stand notwithstanding anything inconsistent. So, the Prevention of Atrocities Act will override other laws save as otherwise provided in this Act. The provisions of this Act shall have effect notwithstanding anything inconsistent therewith contained in any other law. So now let's take a look at the Supreme Court judgment that was given on March 20th, 2018, which was overturned recently. So the judgment in the case Subhash Kashinath Mahajan versus the state of Maharashtra. Please note this is an important case. So the judgment in this case brought change in some of the salient features of the Prevention of Atrocities Act. So the Supreme Court bench consisting of Justice A.K. Goyal and Justice U.U. Lalit, while observing the case, had passed a few directions which changed some of the salient features of the Prevention of Atrocities Act. The bench had observed that working of the Scheduled Caste Scheduled Tribe Act should not result in perpetuating casteism. So they had cited the National Crime Records Bureau (NCRB) data of 2016, which said that 11,060 cases were filed under the Prevention of Atrocities Act on the year of 2016, out of which 935 cases were identified as false or fabricated cases. So, citing this data, the Supreme Court bench of Justice A.K. Goyal and U.U. Lalit had observed that the Prevention of Atrocities Act was acting in an unfair way and the accused should be given a chance to defend themselves and to prevent the misuse of the law. So, based on their observation, they had given a few directions which we will be looking into now. So, here are the directions given by the Supreme Court bench on the March 20th judgment. So, they directed that the police now conduct a preliminary inquiry on whether complaint under the law is frivolous or motivated before registering a case. So, if you remember, it was not necessary that an inquiry be committed before an FIR was registered. But now, the Supreme Court had directed that a preliminary inquiry be conducted before registering a case. Also, cases filed under Prevention of Atrocities Act should be investigated by minimum of a DSP ranking officer. So the court had also directed that at least DSP ranking officer investigate the case. A public servant accused under the Act can only be arrested after approval from his or her appointing authority. So another direction given by the court is that when arresting a public servant under the Prevention of Atrocities Act, the approval of his or her appointing authority is taken before the arrest is made. In case of non-public servants, the approval of the senior superintendent of police was made necessary before the arrest could be made. Also, the most important direction given by the judgment was that it allowed for the provision of anticipatory bail. So, if we remember, we had discussed sections 438 of the CRPC, which deals with the granting of anticipatory bail. And if you remember, for cases registered under the Prevention of Atrocities Act, such anticipatory bail was not eligible. But now, after this direction, they had allowed for the provision of anticipatory bail and also allowed for the provision of such anticipatory bail by the magistrate court. Previously, it required that minimum the High Court guarantee such anticipatory bail, but now after this judgment, anticipatory bail could be given even by the magistrate court. So, previously restricted to only High Court and above. So, now let's take a look at the amendment passed by the Parliament of India on the Prevention of Atrocities Act. So, this parliamentary amendment was passed on August of 2018. So now let's take a look at the amendment which was passed in the Parliament of India on August 2018. So the Prevention of Atrocities Amendment Bill inserted two sections into the Act. So section 18A clause 1 reads, a preliminary enquiry shall not be required for the registration of an FIR against any person. So now if we go back to the previous slide and look at the directions given by the Supreme Court judgment, they had directed that the police conduct a preliminary enquiry on whether complaint under the law is frivolous or motivated before registering a case. So now the insertion of section 18A clause 1 had essentially nullified or negated the direction given by the Supreme Court. Now, section 18A clause 1 subclause B reads, the investigation officer shall not require approval for the arrest of the accused. So again, let's go back to the previous slide. So if we note that the Supreme Court had directed that in case of a public servant, the approval of the appointing authority was mandated before the arrest. And in case of non-public servant, the approval of the senior superintendent of police was mandated before arrest being made. So now, the insertion of section 18A clause 1 subclause B has essentially negated this, and now the investigation officer shall not require approval before proceeding with the arrest of the accused. Moving ahead, now let's go to the recent Supreme Court judgment dated 1st October 2019. So on 1st October 2019, the Supreme Court bench consisting of Justice Arun Mishra, M.R. Shah and B.R. Gawai upheld the Prevention of Atrocities Schedule Caste Schedule Tribe Amendment Act. We just discussed this now. So it has upheld the Amendment Act, and hence the sections which were inserted, sections 18A clause 1 and sections 18A clause 1 subclause B are now included in the Prevention of Atrocities Act. The Supreme Court also recalled its previous verdict, hence negating the alterations to the Act as a result of the Supreme Court directions given in March 2018 and restored the Act to its original intent. So, after the judgment passed by the Supreme Court on 1st October of 2019, the previous directions given by the Supreme Court have been nullified. So, in essence, all the directional changes that were given by the Supreme Court on March 2018 have now been revoked, and the Prevention of Atrocities Act has been restored to its original intent. The bench also remarked that the judiciary can't presume that Dalits and tribals may misuse the law, and also cited the very low conviction rates in cases filed under the Prevention of Atrocities Act. So this was one of the major criticisms given on the March 2018 Supreme Court judgment, that the judiciary presumed that Dalits and tribals may misuse the law, and also their complete ignorance of the fact that the conviction rates in prevention of atrocity cases were very, very low. So this was one of the major criticisms given on the passed on the Supreme Court on the March judgment. The Supreme Court also condemned its own earlier judgment, saying it was against basic human dignity to treat all scheduled caste, scheduled tribe community members as liar or crook. One of the remarks given by the Supreme Court bench was also that members of the scheduled caste and scheduled tribe, due to backwardness, cannot even dare to lodge an FIR, much less file a false case. So this was one of the remarks given by the judgment. So now, as of now, the judgment has revoked the earlier directions given by the Supreme Court and has included the amendments passed by the Parliament of India on August 2018. So now the Prevention of Atrocities Act has been restored to its original intent. So meet you in the next video of Affairs Cloud. Thank you.